inner circle and the witnesses provided information not known to the public. My question to you is, how do you know that?
Bear with me while I get there, please.
So page 7, right in the middle where it says bias.
Yes, I have it now. The direct answer is I don't know that I do. I can say that I don't know that. I haven't, followed this case in the media and so forth and so on. I think I was referring and reacting more to the sense of the way the information was given. But that, to your point, I do not have a way to demonstrate to you that I don't know that it's not public.
Well, I appreciate the answer because I mean, clearly you haven't talked with Summer Shiflett, right?
I have not.
You haven't watched the preliminary hearing.
I have not.
I didn't see you present at the preliminary hearing. Is that right?
Correct.
And so that's my concern when you're talking inner circle and biases and things known to the public. You don't know what's out in the public, right?
Correct. If I may, though, inner circle is not necessarily something that means it's not in the public. It is a biased effort to draw somebody into an inner circle.
And when you are making comments about what either Summer Shiflett said or Mr. Wood said, this is you summarizing those comments, is that correct?
I guess I'm puzzled when you say I'm summarizing them.
Right. So when you say something like Robert Wood said the following, is that supposed to be a direct quote of what occurred?
Yes, it's a direct quote off the transcript that I have.
Okay, I want to turn your attention to page 9 of 24.
Okay. I'm there.
If you look down about towards the end of the page where Summer Shiflett says, and then Robert Wood says, well, welcome to Chad Daybell. Do you see that portion?
Yes.
In the transcript that I have, do you have that in front of you, by the way?
I don't, but I can pull it up. Just give me a second, please. It's loading.
Turn to page 5 of that transcript once you get it.
I will. Bear with me, please. Page 5. The transcript I have hasn't page numbers, so can you give me a line at the header of the page that save me having to count?
If you look, it says briefly on the phone. Is the first briefly on the phone, never a long extended conversation?
Mr. Evans, do you have the ability to broadcast the exhibit so that the witness, I can make sure he's looking at the same thing you are?
Your Honor, I don't where I'm sitting.
Okay.
And I don't know that I am looking at the same thing, because when I count to page 5, what I have is the transcript provided by Mr. Means, where it has a question mark, colon, well, I'm the visionary guy. And that I don't have any first lines that match with what you said.
Okay, well, let me, and you might have something different than what I have that was introduced into evidence as Exhibit 1. You might have something different. But let me tell you my concern. So back to your report, where you say Robert Wood, well, welcome to Chad Daybell, period. So what I want, and then it drops off. Do you see that in your report?
Yes.
So basically 9 words. Let me read to you what the transcript actually says. So this is page 5 of the transcript, starting in paragraph 8. Mr. Wood, what really he said is, well, good chat, and then he said Daybell. So what I want to kind of tell, and then he's cut off by Ms. Shiflett. I have my own opinions formed from him, and you pick that up at the next line down. I have my own opinions formed of him. The problem is, I think you're misrepresenting
Judge,
what.
I'm going to object.
What's the basis?
No, the objection, Judge, is that he's testifying. Mr. Evans is about to invoke what he thinks the problem is with either the transcript or what Mr. Davidson said. If there's a question that Mr. Evans would like to ask, by all means, and those can be leading questions, at least the way I understand the rules. But I'm going to object if Mr. Evans proceeds to start speculating about problems that he sees in this particular transcript or with Dr. Davidson. That's designed for questions. And if Mr. Evans has a question, by all means, go ahead. He does not get to testify.
I'll overrule that. I thought he was in the process of forming a leading question, so it's overruled, and you can continue, Mr. Evans.
So Dr. Davidson, my concern is what you are putting in your report versus what's in the transcript is different. Do you share the same concern?
Give me one quick second if you don't mind, because I'm trying to find in the transcript I have what you're referring to. Otherwise, I'm operating in the dark.
Your Honor, if I may make a suggestion, we can probably get the transcript exhibit that we are working from to Dr. Davison, if it's okay with everyone, whether through email or some process like that.
All right. I do think it's important because that is Exhibit 1 in this hearing. And so Dr. Davison should be allowed to review the exhibit, and especially where it's brought up that there may be something inconsistent with another document he was looking at. So ideally, we would be able to show this on someone's screen, and whoever admitted the exhibit should have the capability of do that. I understand it's not as easy as when we're in an in-person hearing, but if someone can pull it up on their screen and do a share screen, that would be one way. If not, and the exhibit is a file that we're reasonably sure would be the same thing if it's sent to him by email, I would allow him to just pull it up that way as well.
What I could do, Your Honor, if it works, if everyone's okay, I could get an email together and email the exact exhibit that we're working from, and I could CC Mr. Pryor and Mr. Evans on that email. If you wanted me to also CC the court clerk, I could do that as well. I'm not sure exactly how to share it on Zoom here.
Okay, why don't you just send that as an email, but we'll make clear on the record that the actual exhibit is Exhibit 2, which was admitted, not the email, but the email will be considered a copy as long as counsel can verify that it is in fact the same file and the same transcript. So I think that'll work, Mr. Means.
Okay, if you could give me a couple minutes, Your Honor, I'll get that over and then be right back.
All right.
And Your Honor, if I may,
Yes.
am I waiting for an email from the counselor?
Yes, that's was the plan. Do you have a capability to receive that where you're sitting?
I do.
Okay, so if you'll just hold on a moment, there should be something coming through, then you can open the attached file.
Not a problem. Just wanted to make sure I'm looking for something.
Okay.
Your Honor, would you like me to CC someone at the court with this this exhibit?
I don't think that's necessary, Mr. Means, because we've already got the exhibit, which I do have in front of me.
Okay, and I need to confirm, I don't think we need to do it on the record, but Dr. Davison's email.
Why don't we take a moment and go off the record, either that or a breakout room, and why don't we just have Mr. Means and Dr. Davidson put in a breakout room briefly so that Dr. Davidson can share his email with Mr. Means.
That works, Your Honor.
Okay. So Dr. Davidson, at some point a prompt should come up inviting you into what's called a breakout room, and that will be a discussion off the record that will not be recorded or broadcast.
Understood.
All right. Eileen, do you know if, in fact, the breakout invite's been sent to the witness?
IT is doing that from their side today, Your Honor.
Okay, thank you. Looks like Mr. Means was able to go.
Okay. I see the invite. It was hidden behind my looking for the email. Sorry.
Okay. right, we'll be back on the record here. Dr. Davidson, were you able to receive that file?
I do have it now. Yeah, it took a minute to get it to work.
Okay, thank you. Give you a moment to get situated with that, and then Mr. Evans, you can continue your cross once the witness is ready. All right, are we ready to proceed? Mr. Evans, you can continue your questioning.
Thank you. Dr. Davidson, have you seen the transcript that was emailed to you?
I just received it, so I've just seen part of it as I've gotten it. Yes.
Is this the same transcript that you used to perform your analysis?
No, the transcript that I used was provided by the attorney and was done by a person named Kimberly. I won't use her last name.
Okay, and that transcript was provided you by Mr. Means?
Correct.
Okay, so that's my problem in going through this is from what I've seen, there's two transcripts, what I'll refer to as an unofficial one, which is what you have, and then an official one that we've got into court is Exhibit 1. Make sense to you?
Well, I understand what you're saying.
So if you look at, again, your page 9 and what you're claiming Mr. Wood said, well, welcome to Chad Daybell. So what I want, do you see that on your analysis on page 9?
I do.
And if you look at the transcript that is Exhibit 1 entered into court, page 5, if you can find the page number.
I have it.
What Mr. Wood really said occurs on paragraph 8 and 9. In fact, you can go through that whole
I'm going to
paragraph.
object at this point.
The basis of the objection.
Judge, counsel has just made a statement that I think factually is problematic. The question is what the transcript says, not what Mr. Wood said. The situation is simply this. Apparently, Mr. Means had someone else do an informal transcript, and then there's a formal transcript that's been filed. There is also an audio recording. And quite honestly, I expect, at least from my perspective, what's on that audio recording is consistent with what Dr. Davidson said. So for Mr. Evans to suggest that Mr. Wood said something different, I think is inappropriate. If Mr. Evans wants to say the transcript says this, that's fine. But I would defer to the audio recording and exactly what was said, because I think it would show that it's Mr. Davidson is right on point with what he said on the based on the audio recording.
On that, well, I'm not sure I entirely understand the actual grounds of an objection there. There was some additional commentary, but the issue is there, obviously, that there is a transcript that's been submitted as Exhibit 1 in this hearing, and that's the transcript the parties by stipulation agreed was an accurate representation of the recording. And so I'll allow Mr. Evans to continue a cross-examination using the transcript if he wishes, and if you want to go back on redirect and find something you think's inconsistent in the recording, all right, you're right to do that at a later time, Mr. Pryor. So Mr. Evans, continue.
So Dr. Davidson, if you look at what Mr. Wood said in the transcript, paragraph 8 and 9 and 10, well, good Chad Daybell. So what I want to kind of tell. Do you see where I'm reading at?
Yes, I do.
And then what you put in yours based on the unofficial transcript is, well, welcome to Chad Daybell, so what I want. You see the discrepancy?
I do.
And I see that throughout your entire report. In fact, if you just go down to the next line of Summer Shiflett in your report, I have my own opinions for him. Don't get me wrong. That's not what she says. I have my own opinions formed of him. It's different. You would agree with me that the transcript that you relied on for your 24-page report is different than the one that we're relying on in court.
I'd have to compare them because I haven't had a chance to review this exhibit. I note what you pointed out thus far to have some differences.
Because your best practices and bias based on that line that reads, well, good Chad Daybell. So what I want to kind of tell, that's what Mr. Wood really said. And you were saying that's improper based on best practices and bias. And I don't see it. Do you, based on what the actual transcript says?
Well, let me take a look at it because you're asking me to look at the information and come to a conclusion. So give me 1 second. Darn it.
And so it's page 5, paragraph 8, 9, and 10.
No, that wasn't the problem. The problem is this is electronic and it just closed the document on me.
Okay.
Okay, so bear with me for a minute. Page 5. And almost there. And so your question, do you want to re-ask your question or do you want me to tell you what I think your question was?
Let me re-ask my question. Based on what the actual transcript states Mr. Wood said, is your conclusion still the same, that it's a best practices violation and a bias?
Okay, and so in terms of, and I'm going back and forth between documents, so you got to excuse me. So in terms of mutual activity, I don't think it changes what I would say there because it's still talking about defining or refining what it is that we're trying to do, or that in quotes what they're trying to do. And in terms of confirmatory bias, the language is slightly different. But I don't think it significantly changes that either, because instead of so what I want, it's saying so what I want to kind of tell, which is again just a different way of saying he's going to pursue a narrative.
So with the statement of well, good Chad Daybell, so what I want to kind of tell, and he's cut off, by the way. He doesn't even say the rest of it because Ms. Shiflett cuts him off. With just those statements, that's a problem to you.
I just said to you, I don't think materially they would change what I wrote.
Dr. Davison, obviously you're hired by the defense, right? Or Ms. Vallow in particular, is that correct?
Correct.
What I mean, you're not court appointed. I mean, you're being paid to be here today and make this report. Is that right?
Of course.
How much are you being paid?
My hourly rate's $275. So,
Dr. Davison, looking at this, I mean, you've got an 18-minute tape that you looked at the wrong transcript of, and you came up with 24 pages worth of problems. My question to you is, have you ever seen?
Sorry, counsel, I'm going to object to the characterization of wrong transcript. That's all inclusive. We have a point out of 1 page on page 5. I do not think it comes to the conclusion that it's a wrong transcript. If he wants to make reference to a specific paragraph or page, that's fine, but I think that's inappropriate.
And Judge, in additional response, Dr. Davidson's report is based also on the actual recording, which is what my comment earlier was. That Mr. Evans can say what he wants, but I will defer to what's exactly said on that 18-minute tape. And although the transcript, the official transcript, differs from what Dr. Davidson has, which apparently Mr. Means got him an informal transcript, I would defer to the recording as to what exactly each of the parties said. And I agree that Mr. Evans is mischaracterizing the evidence in this case.
I'll just also sustain that objection as it relates to the description of the wrong transcript. I think it was a different transcript, but Mr. Evans, if you want to re-ask or continue with another question.
And you're on my comment. I know we're going to be here all week, but I would just point that out to the court. The court can go through that very quickly with what our transcript is based on what Dr. Davidson is and look for yourself. I don't want to go into every single detail, but it is different. So I'll continue on with my questioning. So Dr. Davidson, my question to you is, have you ever seen best practices testimony? When you're paid to dissect interviews, have you ever seen best practices, or have you always found fault?
Well, I think I've seen best practices, yes.
So you've justified when
Judge,
Go ahead.
could I allow Mr. Davidson to answer the question before he's bombarded with another question, please?
Well, counsel, that's just proper court decorum. Please allow the witness to complete the statement. And Mr. Pryor, I admonished everyone to do that when we started because we are making a reporting of these proceedings. So that it can be difficult on Zoom. I understand, but just please allow time between responses.
So may I finish, or?
Go ahead.
What I was going to say is best practices are aspirational. You won't find them codified anywhere as required legally. And yes, I have seen best practices enacted. However, no matter what the matter would be, no one's ever going to have perfection. So I'm not suggesting that that perfection is the criteria.
I want to turn your attention to page 23 of your report, Doctor.
Okay.
You go about midway down. The witness is a vulnerable witness. Do you see that?
I'm getting there. Yes.
We've already made it clear you've never talked with Ms. Shiflett, right?
Correct.
Or Mr. Wood,
Correct.
or Mr. Smith, Ms. Shiflett's attorney, correct?
Correct.
I asked Mr. Smith, who probably knows her better than all of us, whether his client is a vulnerable witness, and he said no.
Judge, I'm going to object. That's a mischaracterization.
Yes.
I'll overrule on those grounds.
And doctor, you're saying that no, that she is, but you're saying that based on you've never met her, you've never talked with her. So do you think that you're assuming that she is a vulnerable witness?
If you're saying, am I assuming she's a vulnerable witness? The answer is yes. Absolutely.
Dr. Davidson, have you ever seen a prosecutor disqualified from a case based on an interview?
Judge, I'm going to object. Relevance.
Yeah. Same objection, Your Honor.
Overruled. I think it is relevant.
Dr. Davidson, did you hear the question?
I did, just waiting to make sure everybody's cleared the decks on their comments. Have I ever seen a prosecutor recused or excused because of interviews? No, I have not, nor is it something that is even commonplace in my experience to have this kind of hearing.
No further questions, Your Honor.
All right. Thank you, Mr. Evans. Mr. Means, I understand this is a witness you may call yourself. Did you have any cross-examination?
Actually, yes, just one, and then I can, hold on, I just have a few other questions for direct, Your Honor.
All right.
May I go ahead?
Yes.
Oh, thank you, Your Honor. Mr. Evans, the counsel, Mr. Evans brought up the term vulnerable witness. and he represented you of some of the testimony of the previous witness, Mr. Garrett, or the attorney, excuse me, Mr. Smith. Could you please explain to the court how it is that you came to the conclusion that Summer Shiplet is a vulnerable witness according to your report?
Sure. A vulnerable witness is a category for a type of vulnerability in a matter. So, for example, someone could say, I have a person with cognitive difficulties who has an IQ of 65. Have you ever met them? No. Do you consider them to be a vulnerable witness? By definition, yes. I have a person who has been hospitalized several times with significant health problems, and currently they're recovering from COVID, for example. Do you consider them to be a vulnerable witness? By definition and by categorization, yes. So a vulnerable witness here is referring to a person, in this case, who has significant emotional connections to a defendant who is on a very serious charge. And the consequences of that charge could ultimately lead to that person having a capital charge be brought. In her own testimony, she makes testimony in her own statements in the interview, the tape. We have her making various statements of concern. And so that to me just illustrates, yes, this is categorically a vulnerable person, which logically on the surface you would probably define her as anyway. So that is the basis for my answer to the attorney for the prosecutor.
Thank you. Just a couple more questions. You mentioned that you did have an opportunity to listen to the recording of this discussion between Mr. Wood and Summer Shiplet. Is that correct?
Several times.
Okay. And if there were some minor discrepancies between an official transcript you reviewed and an official transcript, you had access to the official recording, correct?
I did.
And would your recommendation, having listened to that official recording, would your recommendations in which you have given in your report, would it have changed?
Not based on what I've heard today, and not based on what I've heard on the tape and looked at with the initial transcript, apparently, that I was provided by you.
Okay, thank you, Your Honor. As far as for cross, that's all the questions I have.
All right, thank you, Mr. Means. Mr. Pryor, any redirect?
No, Judge.
All right, then, Mr. Means, would you like to call the witness in support of your motion?
I would, Your Honor. Just a few questions, like I mentioned.
Very well. You can proceed.
Thank you, Your Honor. Dr. Davidson, just a couple questions. I think you've obviously spent quite a bit of time here today, and we appreciate that time and your efforts in this case. There was an affidavit filed by Mr. Rob Wood entitled Affidavit of Rob Wood in Support of Objection to Defendant's Motion to Disqualify and Prosecutor Attorney and Motion to Extend Time on Motion to Dismiss. I'm going to read you a couple very brief statements from this pleading is in the court record, and then ask for some commentary as far as the statements in this affidavit signed by Mr. Wood. He says in paragraph number 4 of this affidavit, and I quote here by reading, "At no time did I coerce, unduly influence, coach, and or intimidate any witness." Would you agree with that legal conclusion by Mr. Wood?
Your Honor, objection calls for a legal conclusion.
Your Honor, if I may respond.
Yes, response.
Asking Dr. Davison whether he agrees with a legal conclusion asserted by Rob Wood is not asking for a legal conclusion for this court, but his professional expert opinion on the words used by Mr. Wood as far as coerce, unduly influence, coach, and intimidate. We're asking for his expert opinion, not his expert legal opinion.
All right, based on that, I am going to overrule that objection, and if the witness has a response, they can do that.
Okay. So if we may, because I'm hearing this rather than being able to read it, one question or one issue is, no, he did not coerce the witness. Is that correct?
Yeah, I could read the sentence again to you if that would help.
No, I'd like to take it one piece at a time, just so I don't trip over one piece or the other. So in terms of coercion, again, I'm not assigning intentionality or lack of intentionality, but I do believe there is an element of coercion in some of the things that I have put in my report. The next part was, if you don't mind, the next word.
Unduly influenced.
I have no reservations at all about there being undue influence in the dialogue narrative that I reviewed. Next was, I think, intimidation.
It was coached.
Coached. To me, the coaching would be compatible with the concept of undue influence, and I would assert that that was present. And then was there intimidation?
There's intimidate any witness.
I didn't perceive that somehow this person was intimidated.
Okay.
I mean, intimidated in the sense of a threat. I mean, there's some intimidation probably, I suppose, in the religious connotations that were brought out that would be, to me, probably intimidating. I guess when I hear that word, just that's why I wanted to unpack it one piece at a time. Raised fist intimidation, no. Intimidation at a lower level on a spectrum of that concept, yes.
Okay. I'm going to read you this sentence again and then ask you about one more section. Paragraph 4, at no time did I coerce, unduly influence, coach, and or intimidate any witness. And this is the part I'd like your commentary on. He says, or instruct a witness how to respond to any question by law enforcement. The question I have for you is the portion of that sentence where he says, instruct a witness how to respond to any question. Would you agree with that?
I think I would agree with that because I don't see in what's being said any directives except that it's going to be hard, very hard to go through the law enforcement interview. So as far as a directive, you go in there and testify X, Y, Z, I don't see that.
Okay. Paragraph 7 of the same affidavit, and I'll read this to you, and then I give minutes and ask you for your commentary, your expert opinion. Mr. Wood says, the meeting I attended with Mr. Smith, Mrs. Shiflett, and Miss Pastines came about as, the meeting I attended with Mr. Smith, Mr. Shiflett, and Mrs. Pastines were introductory in nature. Now, we haven't had a conversation with you regarding the interaction discussion between Mr. Wood and Mrs. Pastines, but as far as the recording you reviewed of the conversation between Mr. Wood and Miss Shiflett, would you agree that it was introductory in nature?
I would not, and that's why in my report there's a notice about the GMAC concept, greeting, and so forth. No, the material that I read was hardly introductory at all. It was quite
Did
different.
you see any instance or communication that was introductory at all in that recording?
The only thing I mentioned, and it's in the report, is thank you for coming. That to me is the end of an introductory orientation.
Okay, Your Honor, thank you. I have no further questions.
All right, any cross-examination, Mr. Evans, on those questions?
No, Your Honor, thank you.
Mr. Pryor, do you have any cross-examination?
2 questions, Judge. Dr. Davidson, you said that without reservation, this witness was coached. Is that your testimony?
I don't think I said without reservation, but yes, I do believe they were coached. In terms of having any reservations, I don't have reservations per se. I just want to make sure I'm clear that I have no question in my mind that this categorically is coaching. Would there always be a way to qualify that in some manner, shape, or form? I'm sure.
Okay, and then as a follow-up, you have no reservations that Mr. Wood was attempting to influence Ms. Shiflett.
Well, that speaks to his intentionality and his purpose. I can't speak to his intentionality. So whether it's intentional or unintentional, yes, I do believe that it influenced the witness.
Okay, thank you. Judge, I have nothing else. Thank you.
All right, I believe then that would conclude the testimony of Dr. Davidson. Dr. Davidson, if there's nothing further then, is it okay with counsel if he leaves the meeting and is dismissed from the hearing?
Yes, Judge.
Yes, Your Honor.
Thank you. Then you can go ahead and log off. Thank you for the testimony, Dr. Davidson.
Thank you, Your Honor.
You can call your next witness.
Judge, we would Call Dr. Samuel Newton.
Very well. All right, good afternoon, Dr. Newton. Can you hear me okay?
Can hear you just great. Can you hear me?
Yes. All right, you've been called as a witness in this case. I will have you raise your right hand if you would, and I'll have Madam Clerk administer the oath, please.
Do you solemnly swear or affirm that the testimony you're about to give in the cause now pending to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
All right, before we get started, Dr. Newton, I'll just advise you, we are conducting this hearing by Zoom. You're obviously using a computer to do that. I would ask that your testimony be from your knowledge and you not refer to any extraneous materials that you have unless you are allowed to do that or we agree to do that, and then you can reference what those are for the record. So with that in mind, then, Mr. Pryor, if you'd like to commence with your direct examination, you may do so.
Sir, would you state your name and spell your last name for the record for me, please?
Daniel P. Newton, Newton.
And Dr. Newton, you and I have never met, is that correct?
That's correct.
And you and I have never spoken prior to this this hearing?
This is the first time.
And that you are have been retained by Mr. Means, is that correct?
That's correct.
And Dr. Newton, would you tell me or specify what your occupation is?
I'm a professor of law at the University of Idaho College of Law.
Okay, can you tell me a little bit briefly about your educational background?
Sure. I have a Bachelor of Arts degree from Weber State University in Ogden, Utah, in political science, a law degree from the J. Reuben Clark Law School at Brigham Young University, and a PhD in United States history from the University of Utah.
And how long have you been a professor at the University of Idaho, Doctor?
Since 2018.
Okay. And what coursework do you teach at the University of Idaho?
So I teach criminal law, the death penalty, evidence, criminal procedure, both investigations and what we call adjudication, which are the post-charging stages in a criminal case. I also teach advanced topics in criminal law.
Okay, I would like to talk a little bit about your legal background and the type of cases that you've been involved in your career.
Yeah, I have interned or worked at prosecuting offices, United States Attorney and the District Attorney in Weber County, Utah. But most of my career was spent as a public defender, both in Salt Lake City and in the state of Montana with the Office of Public Defender there.
And if you could touch on a little bit about the type of cases and the judicial districts that you've represented clients in.
Yeah, so I started my career as is common for a public defender working in misdemeanors, thousands of defendants in a variety of misdemeanor cases in Salt Lake City, which was, an urban environment. I then moved into the felony division of the public defender in Salt Lake City and handled major felony crimes, including some capital casework in my time there. I was there for 7 years at the public defender's office. After that, I also worked for at one point I worked for the state of Montana in the Office of Public Defender, handling major felonies in that office. And then I have handled exclusively myself some capital cases, death penalty cases. As solo counsel or as the only attorney on the case, I handled 2 capital cases as the only attorney. I've also participated as co-counsel on I think 3 or 4 other capital cases. And then I have probably authored close to or participated in close to 100 appeals before the Utah Supreme Court, Utah Court of Appeals.
So you've participated in appellate work as well, is that right?
I exclusively almost did appellate work for quite some time.
Okay. And are you published, Doctor?
Yeah, I have a published book. I have another book that's on review right now with Oxford University Press. We'll see if it gets published there. So I'll have a second book coming out here in a bit. And I've published probably 3 or 4 articles in criminal law, criminal procedure.
And then you have a PhD, because I'm referring to you as doctor. So I'd like you to talk a little bit about your advanced doctorate degree, if you would, sir.
So my PhD is in United States history with a specific focus in Mormon history. And that's the subject of my upcoming book, which is on 19th century Mormonism and resistance to law in 19th century Mormonism.
Okay, all right. Now I would also like to talk a little bit about your research that you have conducted, because you've worked on a number of things and you've been cited as part of your research that you've done during your current occupation. Is that right?
Correct.
And would you talk a little bit about that research where you've been cited in various publications?
So I've published articles on kidnapping. I've published an article on kidnapping and its history and kind of some of the problems associated with that. I've done articles on sex offender registries. I'm working actually on 3 articles right now that are related to capital litigation, kind of the specifics. You asked about my published work. I'm trying to remember everything off the top of my head.
Now, what I would ask you is, I apologize.
I just say I published a book on criminal evidence with the nation's really one of the top legal publishers for criminal evidence.
Now, you have also submitted some amicus briefs as well, correct?
I have participated on them. I have authored, I think, but most of my work amicus wise has been participating as with somebody else being the author, or an advisory role maybe is a better way to put that.
You've been contacted by various media outlets throughout your career to offer expert opinion on criminal law and criminal procedure questions. Is that correct?
Frequently I get called often specifically in Idaho cases.
Have you ever been qualified as an expert in a criminal case?
I have not.
Okay, so this is a new opportunity for you.
Correct.
Judge, at this time, I'm going to ask that this witness be qualified as an expert to testify in this case.
All right, any objection from?
Your Honor, I do have an objection to this. I don't think he qualifies under Rule of Evidence 702. Also, per his declaration that is with the court, paragraph 68, he says, "I do not believe I can make a conclusion. I'm not familiar with the evidence of the case." And so what I see him providing, and frankly, I don't fault a lot of it, but just the legal research and writing on that, I don't think that he should be qualified as an expert.
All right, and Mr. Evans, what was your citation again to the conclusory paragraph that you mentioned?
Yes, Your Honor, it's paragraph 68 of the declaration of Dr. Samuel P. Newton, page 19.
Your Honor, may I respond to the objection?
Yes.
I think it's quite a simple response. I think Dr. Newton is avoiding coming to a legal conclusion and leaving that determination to the court. He's saying that his evidence and what he's been provided is he provides his opinion, the legal analysis of the case per statements from the recording. And he says, I cannot make a conclusion, does not invalidate him on the face as an expert. I think that's actually goes to his candor and credibility that he doesn't extend himself beyond where he should be.
All right. Counsel, I'm going to take a quick recess for about 5 minutes and briefly again review the affidavit in support of the objection. And I will come back on once I've had a chance to do that and make a ruling. So we'll take a quick break.
Judge, could I briefly respond to their objection to the certification as an expert?
Yes, go ahead.
Judge, if you look at number 68 that they're referring to, I believe that Dr. Newton's going to say that it's the prerogative of the court to make a decision whether Mr. Wood has committed prosecutorial misconduct.
Okay. Consideration, give me a moment to review this, and then Any additional argument on the objection, Mr. Evans?
Your Honor, thank you. I just, I'd also point the court to paragraph 70 at the very end, where he states, I can't determine the extent of which the pressures may have motivated Ms. Shiflett to change her testimony. And then if he's right before his signature, nor can I determine what effect the conversation may have had on her subsequent statements. So again, I'm referring to paragraph 68 and 70 of page 19 and 20.
Okay.
Judge, if I could respond on that, if you look at the last sentence of number 70, you will say, but the pressure and incentives were there. So he quite honestly suggested that there were incentives and that there was pressure imposed by Mr. Wood. The other issue, Judge, is whether or not he comes to a conclusion is irrelevant. The question and the objection was his standing as an expert witness. Now, this is the gentleman who has practiced law for a significant period of time. He has a doctorate. He is teaching upcoming law students about criminal law, criminal procedure, and I'll get into some other matters. Quite honestly, I can't think of anyone who's better qualified.
Mr. Pryor, I heard his credentials in the opening of his testimony. I'm going to take a moment to carefully review the paragraphs in the affidavit. I'll be back on with the ruling in just a few moments.
Thank you, Your Honor.
Oh, there I am. Hey guys. So, okay, I know I look like heck and I'm just in my living room here. I've got my baby Wyatt that I'm watching, but this is a crazy little thing that's going on here right now. I didn't expect this at all. Like to have the prosecutor be brought up on charges like this. That's very serious. And I hope that it does not affect the ability for this case to go forward in some way. We will be following this throughout the week if they continue on. So you guys are going to want to tune in here to do that. And then as soon as this is over around 6 o'clock, I'm hoping it'll be over by 6. We have an update on another case, the Gypsy Rose Blanchard case. There's some breaking news. So go ahead and tune back in here in just a little bit. Amanda will be joining me at 6 to talk about the Gypsy Rose Blanchard case. Let us know what you're thinking about what's going on here in this Vallow case. Just when you think this case couldn't get any crazier, here it is. It's totally freaking crazier. So I feel like every day with this case, there is something new that you're like, what? I mean, it's just stuff that has never happened before. So I can't wait to see how this case kind of shakes out in the courts. It's going to be a very interesting case. They still have not brought murder charges against either Chad or Lori, which is interesting to me. They do have them on, they do have them on collusion and conspiracy. So hopefully that will still get them, a pretty hefty charge. And I think that the murder charges are coming. I think it's just that they need to put all their ducks in a row. So something like this kind of thing doesn't happen. All right, guys, I'm going to pop off. I'm just going to leave it streaming because they're only going to be broken out for about 5 minutes. So if you guys have questions, comments, things that you want to talk about this case, please let us know. We've been following this case for a very long time. We have been talking about it since the day it broke. We are going to do another dedicated 24-hour live feed this year for JJ entirely on the day that the Vallows said that it was that the world was going to end, and it will be in honor of them. And I think we're going to have a lot of different people involved in that. We're trying to get some different podcasters and our experts, of course, involved in that case and in that thing that we're doing. And we're also looking at doing a wine and crime where we're going to do a cold case and let you guys kind of sift through the information. So keep sticking with us. We'll see you a little later, but I'm going to leave you guys on here just watching the little thing until they come back. And I'm sorry if my dogs bark, guys, while this is happening. Of course, we're all going through COVID and dealing with being at home instead of in our studios or anything like that. So please, I'm very sorry if that is an issue. But have a good one, guys. I'll see you a little later. Hopefully we'll wrap this up soon and we will talk about the Go to John and Gypsy Blanchard case coming up. Thanks. There we go. All right.
All right, we'll be back on the record here. The court took a brief recess to review the objection that was made regarding qualifications of Dr. Samuel Newton to testify at this hearing or provide an opinion. I've considered the objection. I've also reviewed paragraphs 68 and 70 of his affidavit. In addition, I've considered Idaho Rule of Evidence 702, which indicates that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. And so upon consideration of that, I've taken into account what Dr. Newton does in terms of professor at the University of Idaho College of Law, also his educational background and the foundation laid by Mr. Pryor. And based on that, I am going to overrule the objection and allow the expert testimony of Dr. Newton in this matter, of course, subject to cross-examination by the state. So you can continue, Mr. Pryor, with your examination.
Dr. Newton, are you there?
Yep, I'm here.
I don't see your picture, so I'm waiting.
Can you hear me?
I can't, oh, now I see the picture, okay. Current situation makes this incredible having to do this way, but unfortunately this is what we have, so.
Well, and we're teaching classes this way too.
To move on, Mr. Woods retained you to review an audio tape that he viewed as problematic. Is that correct?
Did you say Mr. Woods?
Mr. Wood, I apologize. You know, I've done that a couple times now, and maybe it's just a long day. I'm not sure what it is. It was Mr. Means retained you to review an audio tape that he determined to be, in his mind, problematic. Is that correct?
Correct.
Okay. And what did you review as part of your review of this particular issue?
So I laid that out in my declaration. I can, off my memory, I can say that I listened to the audio recording. I read a transcript. I read an affidavit of Rob Wood, an affidavit of Garrett, I'm forgetting his last name, Smith, maybe. And there might have been one or two other things, but it's in my declaration.
Okay. Now, you made several references in your declaration that was filed and presented in this case by Mr. Maines in his disclosure, and I did not see by Mr. Wood or Mr. Evans that there was an objection to your declaration. But in essence, you touched on a number of issues. Initially, you started with the Idaho Rules of Professional Conduct. You recall that?
Yes.
Okay. Now, as part of your occupation, are lawyers, before they enter into the field of law, instructed on ethics and the Idaho Rules of Professional Conduct?
Yes, they are. And it's a required course at the University of Idaho. While I don't teach professional responsibility, it is that course. It's a heavy part of my discussions in my advanced topics in criminal law class and in my criminal procedure adjudications class. We talk about.
And you're familiar with those rules, obviously, having to have the responsibility of teaching up and coming lawyers. Is that correct?
Correct. And I frequently will reference the rules, frequently bring them up with students and talk to them about their responsibilities.
Now, in this particular case, I'm looking at your declaration and I'm referring to item number 18 in your declaration. I know that all the parties in the court have been provided with this, but you talk about initially the canons of professional conduct, specifically Rule 1.1 competence.
Do you want me to refer to my?
Yeah, do you have a copy of it?
I do have it, but I haven't pulled it up.
Would you pull it up? And then obviously you're aware of how the rules work because you're a lawyer. I would have you refresh your recollection on number 18 and then let me know when you're ready.
Okay.
Mr. Pryor, do you intend to admit the declaration?
Judge, I was going to have him testify about a few of these items. My understanding, Judge, and the reason I brought up the pleadings is Mr. Means submitted this. It was accepted without objection. So from my perspective, the declaration is all part of the case already. But if I need to do a formal motion to admit the declaration, I'll do that at this time.
Okay, yeah, the declaration, just because it's filed in the case, it is a statement of the witness. And for purposes of this hearing, would need to be marked as an exhibit, and we would have to see if it's admitted or not.
So I will ask the court to do that at this time, if I may.
All right, well, this is the declaration of Dr. Samuel Newton that was filed on January 5th. This would be, I believe, Exhibit 4. And it's been offered. Is there an objection to the declaration?
Your Honor, there is.
What's the basis of the objection?
We don't know. In fact, let me just show you on this. Dr. Newton is referring to a recording and an official transcript. As we know, and that's in paragraph 15. As we know from the last witness, I don't know what official transcript he's looking at. That was a problem with the last witness. And then also we think there's obviously some discrepancies in here based on what the official transcript does say. So that's our objection.
And Judge, the objection doesn't go to the admission of the exhibit. If counsel would like to try to argue that there's some problems in the way Dr. Newton prepared his report, that's cross-examination. And from my perspective, the exhibit comes in, it's properly presented to this court, should be admitted. And if counsel wants to make some argument as he sees fit in that declaration, by all means, let him do it. But from my perspective, the document comes in.
I understand. I want to make a clarification to the witness, Mr. or Dr. Newton. You do refer to something you call an official transcript.
Correct.
The document you referred to called an official transcript, was that a certified transcript? We do have an exhibit in this case of a certified transcript. Is that what you were using when you prepared that?
And I can, if you give me just a second, I can pull up exactly what I referred to. It was given to me by Mr. Means.
Okay.
Let me just look here.
What I'd be looking for is one that contains a certificate of a court reporter.
Yeah, it was definitely in court, and I pulled it up. Oh, sorry, Judge, I interrupted you. The powerful litigation support, court reporting, recorded conversation. Do I see the certificate in the back of this? It does not. It's a transcript prepared by Nagley, deposition and trial.
I do think that's the same one if it's prepared by Nagley. So I just want to put that in context. Apparently there's two different transcripts floating around out there.
Your Honor, if I may, to help clean up the court, on page 25 of the transcript he's referring to, there's a certificate there, but it's all typed very similar to the other font. So that's where he might be missing that certificate.
Oh, I see it. I looked on page 25. That's what I have.
Okay. Based on that, then I do agree that would be proper cross-examination if there's a question on the what was relied on. So in terms of admissibility of the exhibit, I will allow the exhibit to be admitted. So that will be admitted for this hearing as exhibit number 4. And you can proceed with questioning Mr. Pryor.
So Dr. Newton, you made reference to the Idaho Rules of Professional Conduct. And in paragraph 18, you made reference to how a case, prosecution and defense is to proceed. Can you elaborate on that a bit for me?
Yeah, I think one of the most important things maybe to say at the outset is the rules of professional conduct, rule 1.1, require every attorney to be competent when he or she is preparing a case for trial. And one of the canons of ethics that's very strong is that attorneys should be interviewing witnesses that are participants in the case. And so I wanted to qualify anything I was saying here by saying the prosecutor, I believe, has an obligation under the rules to be interviewing witnesses.
Okay. Okay, so then you refer to item number 20 on your declaration. And you make reference that there's been some disclosure of information to Ms. Shiflett. Do you view that as problematic on your number 20?
Let me just look it over real quickly. Yes. Now, I will say, generally speaking, I don't think that this is a violation of the rules of professional conduct to provide a witness with information that the witness is not already familiar with. However, that said, it could be a violation, and I'm just not familiar enough with the evidence in this case. But if the witness is not supposed to be knowing this information, and that's fed to somebody in a way that would cause them to falsify their testimony or to give testimony in a way that's contrary to what they would testify, then yes, that is a violation of the rules of professional conduct, and very well maybe a violation of due process. So it would really depend on what the information was and how important it is in the case.
Okay, what about making disparaging remarks about another attorney to a material witness? Is that problematic?
Yes. Now, that is clearly prosecutorial misconduct. I think I cite in the declaration, there are repeated Idaho Court of Appeals and Idaho Supreme Court opinions that say in front of a jury, it is misconduct to disparage opposing counsel. Whether it's reversible, I suppose, is a different question. But now, I don't know if that answered your question. That's in a trial setting. Outside of trial, it certainly is problematic for the reasons maybe I outline in my declaration. But.
Okay, now let me ask you this, that obviously invoking religious beliefs is problematic in front of a jury.
Correct. That would be misconduct, equally misconduct, and I believe
Automatic disqualification.
I wouldn't push it there, but I would say it could be disqualifying, or it is clearly, and the courts have labeled it misconduct. And when you're looking at appellate decisions, the courts have stepped back to say, well, is it harmless? Did it affect the rights of the defendant? Those seem to be the questions that the appellate courts are looking at there.
So under the Idaho rules of professional law, Rule 8.4 discusses misconduct. Are you familiar with that rule?
I am.
Okay, and it says that it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct. So if a lawyer violates the rules of professional conduct, he's committed misconduct. Is that fair?
Correct.
So if Mr. Wood were to have committed a violation of the Idaho rules of professional conduct, he's committed misconduct.
Well, prosecutorial misconduct and bar discipline are different legal standards.
Okay, so let's talk about that. What do you believe is the legal standard for someone who is accused of prosecutorial misconduct?
So I would say the two seem to be at least the strongest kind of aspects in the court are if a prosecutor, and this really comes from the Supreme Court of the United States as well as from, the Supreme Court of Idaho and Court of Appeals of Idaho, which is prosecutors can violate the due process rights of the defendant if they're manipulating witnesses. That's what the court said in United States versus Ash, 1973. Skilling versus United States, the court said kind of a similar thing, which is, we shouldn't be subjecting witnesses to outside influence, improper outside influence. And I think I quoted in my declaration, Getters versus United States, where the Supreme Court said, there's this line between talking with a witness and improperly trying to influence it. So the improper influence for a prosecutor can result in misconduct, reversible misconduct, if it's affecting the rights of the criminal defendant.
Okay, so I'll go back to my analysis of the jury setting. If a prosecuting attorney calls a defense counsel incompetent in a jury setting, there's going to be a problem. Is that correct?
Correct. It would be misconduct. Whether it's reversible might be another question.
Okay. Reflecting on your religious beliefs and asserting those religious beliefs, that's problematic as well.
Correct. And the courts have labeled that misconduct.
And referring to a defendant, such as calling a defendant a wimp or that he was about to pee his pants, that's problematic as well.
I don't know if I can say under the rules of professional conduct, but I would think most courts would find, at least in front of a jury, that would not be tolerated.
Now, you've talked about this, the jury and how this is in front of a jury. This is clearly misconduct.
Correct.
I guess my question is, if you go to a witness and engage in influence or coercion before that witness has to get in front of a jury, isn't that more problematic?
I mean, it could be. It could be. The rules of professional conduct are very, you might say strict or narrow is maybe a better word, in the sense that a prosecutor or any attorney really for this matter should not and cannot get a witness to testify falsely or contrary to their own opinions. And that's improper across the board for any attorney to be doing that. And that's disbarable, if not criminal, right? And so for a for a prosecutor to suggest to a witness that maybe can you ask me the question again, because I've kind of.
Well, I guess my question would be this, is that if a prosecutor continues to push a narrative and that causes that witness to change her answer, that's disbarment and that's criminal activity. Would you agree?
Correct. If the person was unduly influenced to falsify their testimony or to testify contrary to what their own opinions would be, and I think under Idaho code, it's freely, fully, and truthfully is what comes to my mind as the standard.
182602.
Yeah.
2604.
If a witness is pushed enough that they no longer testify freely, fully, and truthfully, that's a violation of the rules of professional conduct, a violation of criminal law, and really problematic on a host of levels.
Well, to go further, it's also problematic if you influence a witness and encourage a witness a certain manner, is it not?
Your Honor, I'm going to object at leading.
Sustained.
Is it problematic to influence a witness to testify a certain way?
Hang on, there was an objection, but the witness answered quickly, so I'll strike the answer where he answered in the affirmative. And then Mr. Pryor, you can ask your next question.
Do you believe that it's problematic for a witness to be encouraged to testify a certain way?
No, I don't. Witnesses, a prosecutor can, or any attorney can say to the witness, hey, are you comfortable testifying about this or whatever? What's improper is unfair or undue coercion, and especially if that unfair coercion causes someone to testify falsely.
So in listening to this tape, where are the areas that you find concerning?
So I think I've laid these out, but generally speaking, and of course I'm an outsider stepping in, and I have to qualify this, and I think I've tried to qualify it in the declaration of where I see that this is butting up against the rules of professional conduct. And I think the easiest summation is something I would probably say to my law students, which is this conduct going to get you disbarred? Is it going to land you in jail? The answer is probably not. Is it pushing the ethical boundaries to their limit and maybe even crossing them? The answer is yes. And I would say to them, no case is worth that. No case is worth pushing a witness. No case is worth trying to push somebody into a specific narrative. And avoid it as much as you can. Don't create problems in a case. Don't create a bad record in a case. Don't hurt yourself, your credibility with the court. Don't have to have unnecessary hearings where they never need to happen. Just avoid it. So that would be my summation is of what I think of this particular encounter is that I feel like the prosecutor is giving a narrative to the witness, incentivizing the witness to tell a specific story and providing her with, a little bit of, subtle pressure that would encourage her, I think, to give a story that would coincide with the state's theory of the case.
Does this cause you pause in terms of how this case may proceed in the future?
Absolutely. I would think it would open up a Pandora's box that doesn't need to be opened and create a host of issues, again, that don't need to be there.
That's assuming that, and I'm sorry, I interrupted you. Go ahead.
It's okay.
Go ahead.
I've forgotten where I was going to go.
You were at a Pandora's box by allowing Mr. Wood to continue.
I mean, could the court keep the prosecutor on the case? Absolutely. I have to qualify this by saying, is it misconduct that crosses the line? I can't say that because I don't know what Mr. Wood's motivations are. I don't know what Ms. Shiflett's motivations are. I'm tangentially aware of the case, but I'm not familiar enough with the evidence to make, and I'm not an expert on, the interactions like Dr. Davidson is. I did read his report and he would be much more qualified to testify about those pressures. But again, what I would say to my law students is when you push this ethical line with a witness, you're creating a host of problems that you don't need to have on a case.
Well, what other problems would you be referring to?
Well, because the allegation that you've unduly influenced a witness and you've engaged in these kind of private conversations or pushed people into a specific narrative opens up this door that then, as a reasonable attorney would question whether the prosecutor has been doing this in other scenarios with other witnesses. Has the prosecutor been engaged in similar type of behavior and pushing people into narratives? I would think it would be reasonable for an attorney to question whether Summer Shiflett's testimony has been prompted or motivated. And I don't know what her subsequent testimony is. But if her subsequent testimony threw Chad Daybell under the bus, and especially if this witness doesn't know Chad Daybell, and I don't know, I'm not familiar enough to say that, but if she does not, that feels to me like exactly what the encouragement in this interview was. Blame Chad Daybell, he's the main person who's the cause of this. Protect your sister by cooperating with the state in this case, and encourage her to talk with us. If we do that and throw him under the bus, things are going to go better for you. And you're doing this with a witness who is about to talk to the police. I mean, you just really want to avoid all of those problems because you're butting up against Rule 3.3, you're butting up against Rule 3.4, you're butting up against Rule 8.4. And, does it cross the line? Maybe, maybe not, but you're getting so close to it that you've just kind of introduced the complications of your own professional conduct into the case, which should never really be interjected to begin with. So I would tell my law students, stay a mile away from that. When you're interviewing your witness, let them talk, just get the statement. Don't ever try to unfairly influence that. And then you don't have that problem.
So you can't say to a specificity whether this was witness influence or whether it was not. You can't say to a certainty. Is that fair?
I think I can say it's coaching clearly under just what the established guidelines are, which is not necessarily prohibited. You can coach a witness. To some degree, the law encourages lawyers to sit down with the witness and work with them before they testify. Where it's improper is undue. And what I can't say is whether this witness felt pressure to change her story, which is where this would become ethically problematic.
And you suggest, oh, I'm sorry, go ahead.
And I do feel like those pressures and those incentives are present in this interview. Whether this witness does follow through,
I'm live on stuff.
the classic example would be this witness is inclined to protect Lori Vallow when she comes into this interview. She wants to come in and she wants to help.
I'm sorry, I didn't bring your shoes.
As a result of this interview, if she says, "Oh, the best way I can do this is blame this all on Chad Daybell," whom I don't know very well, and is now pressured to act and testify falsely, that is misconduct. And that interview really pushed her over that edge. But I can't say that because I don't know what Ms. Shiflett's motivations were. If Ms. Shiflett is coming into this situation inclined to throw Chad Daybell under the bus to begin with and to protect her sister and to do all of those things, then she wasn't unfairly influenced by this particular interview. And it would just be somebody talking to her and encouraging her, but she's like, yeah, I'll do that anyway. That's not necessarily improper. So, but the reason I think it's problematic is because you're coaching the witness, because you're sharing a theory with the case and actually derogating some statements that she makes that are contrary to that. You have interjected and pushed against all these ethical boundaries to the point that it may be misconduct, especially if she changed her testimony.
Would it be a situation where a prosecutor has suddenly become a witness in this case?
I don't know what the prosecutor's knowledge would be, but if the prosecutor has particular knowledge that would make him a witness, so this encounter was such that is important in the lay of the case, and it's important. I don't know Ms. Shiflett's importance in this case and how critical that is, but if the prosecutor has shifted her testimony and affected that, then yeah, it's important.
I don't know. I just really want to get this stuff in the back room.
This witness has changed her testimony because of unduly influence by the prosecutor, and I would think it would be reasonable to have the prosecutor testify.
Would you be deferring to an expert such as Dr. Davidson to determine whether or not there's been undue influence?
I think it's reasonable for an attorney to do that. those I think are legal conclusions best left to a court to decide whether there's, but an expert I think can make those conclusions as well. And it is reasonable practice for lawyers to rely on experts in forming their judgment.
Friday or this weekend
Well,
because
if
we
a
got
PhD, a psychologist
I gotta
makes
get
a
spark
reference
plugs
that
and
this is
coils put
undue
on my car.
influence, at that point, we have violations of the Idaho Rules of Professional Conduct,
We
correct?
goes like that.
Don't know if
And
you can
Abby.
say that, because that would be one person's opinion, and granted a very informed opinion and an expert opinion at that. Those are legal conclusions that are either left to the state bar or left to a court.
Okay, but there's a criminal statute that criminalizes unduly influencing a witness, correct?
Correct. I can say there's no question that if this witness was motivated and influenced by this conversation to testify falsely, that's misconduct and that's criminal, and it would cross both of those lines.
What about if this witness was encouraged or had changed her story based on this conversation? Is that criminal as well?
Well, the crime under the Idaho statute is, I'd have to look it up, but my recollection is, or look at my declaration, it's in there, but my recollection is if an attorney influences anyone, actually, it's not just an attorney, if anyone influences a witness to testify less than or prevents them from testifying freely, fully, and truthfully, I think those three kind of have to be present under the statute, which would be they're reticent, they're changing their story to some degree, but truthfulness is an aspect of that. So the witness would have to have been less than truthful, changed their story in some way or another to fit that element.
I'd like to talk to you a little bit about the, I think it's the Getters case. Is that what it is?
Yeah.
Would you talk a little bit about that?
So the court says in that case, there's a difference. And I think maybe I'll back up just a bit to talk about Getters and Ash and kind of skilling all in concert, which is there's an important idea in the Supreme Court's jurisprudence that prosecutors play fairly in their role. And part of that means it's okay to talk to witnesses, but we have this overall obligation of being a minister of justice. The defense attorney has a different role, and that it's okay to discuss testimony, indeed preferred to discuss testimony with witnesses, but it's a different line when we try to influence it improperly, I think is how the court says it in Getters. But you're looking at Ash, and in Ash, the court says, there are so many ways a prosecutor can fudge with this line. And, they can falsify evidence. They can, do this. They can do, they can manipulate different things. But the court says they can manipulate witness testimony. And the court says the remedy in this situation is it's a violation of due process, and courts kind of need to step in. And Skilling kind of says this similar thing, that what should be happening in a courtroom is, the jury should be untainted. Witnesses should not be improperly influenced by what happens outside the courtroom. And in Skilling, it's media pressure, but the court references prosecutors can engage in conduct with witnesses that are manipulating the case outside of the jury room. And what should be happening is the gathering, the collecting of evidence, and figuring out what, as I would tell my law students, figure out the case. Your witness may not give you everything. Your witness may only give you 50% of your case. Well, where does the truth take you? But don't try to manipulate. What the court is saying over and over is don't try to manipulate the truth to help make your case stronger. Stick with the truth, with whatever it is, as bad as that is or as good as that is, and let the jury kind of sort that out at the end.
You made reference on item number 6 of your report to a concept called horse shedding and wood shedding. Would you elaborate a little bit on that for me, please?
Yeah. So in the jurisprudence, this is common parlance, but this has been something that has been common for good or bad since the common law era, which was the lawyer gets out and horse sheds the witness, and it refers to they would take them outside of the courtroom by the line of horses that were sitting outside of the courtroom, and then kind of lay into them, this is what you've got to say. when you come in and testify. And it has been a long-standing principle of the common law that horse shedding is not proper. That taking the witness out and telling them, browbeating them, this is what you've got to tell, come in and tell us what we want to hear. And, it's in modern parlance, we may kind of euphemize this by saying coaching. I do think this is coaching, this interview. And I do think it pushes influence. I do think it kind of pushes into this narrative for the reasons maybe I've laid out.
Okay. And quite honestly, Doctor, it's not your prerogative to determine whether this is influence. It's the judge in this case. Is that correct?
Correct.
So the reason you're hesitating is because the final determination is quite honestly up to the judge once he's had an opportunity to review all the evidence. Would you agree with that?
I agree 100%. And it's the obligation of the court really to make these findings. I can say, based on what I teach law students, that this is ethically problematic. It may even cross the line, but I think the court is in the position to say, did Summer Shiflett shift her testimony unduly? And is that important to the case? If it is, that could be a due process violation beyond the rules of ethics.
Well, I want to break this down a little bit about what you just testified to. First, you said it's problematic. So it's problematic under the Idaho rules of professional conduct. Is that what you meant?
Correct.
It's potentially problematic because what Mr. Wood did potentially is a criminal act.
Correct.
Potentially.
Your Honor, I'll object leading the witness and testifying.
I'll rephrase.
Go ahead, rephrase, and I'll strike any answer to that.
Is it possible that Mr. Wood may have violated a criminal statute in this case?
Your Honor, again, it's leading the witness.
It's not really a leading question, just asking if it's possible, so I'll allow the question.
Absolutely, if the witness was incentivized or influenced to testify falsely.
Okay. When you talk about due process, the due process you're making reference to would be filing a motion to dismiss the charges because Mr. Wood's conduct created the situation where this case could not go forward. Is that what you're referencing?
Not necessarily. So a defendant has a constitutional right to a fair trial. And if a prosecutor has improperly influenced a witness who has material value to the case, if this is a witness who, and this witness has been unduly influenced, testify especially falsely. I mean, the classic example you can think of is a prosecutor who comes into a witness and says, the witness says, hey, I saw Johnny run down the street. And the prosecutor says, that's not my defendant. My defendant is Phil. And you need to say you saw Phil running down the street. And the person says, well, I'm not sure I'm going to do that. And the prosecutor says, well, I'm going to charge you with something if you don't say that. Well, now this witness has been improperly influenced. And this witness comes in and testifies that Phil was the one who ran, the witness that they saw commit the crime. That is a wrongful conviction, and the prosecutor has subordinated perjury, has violated, 3.4, 3.3, 8.4, every one of the rules of professional conduct that prohibit presenting false testimony, and he's also violated the Idaho statute. And on top of that, I would argue, and I would think that a court would find that would be a due process violation, and the defendant was deprived of the right to a fair trial due to the prosecutor's undue influence. So it would really depend on, go ahead.
What you have dissertated in this testimony is that there is a possibility of the broad spectrum of these possibilities in this particular case. Is that fair?
I'm not sure I understand the question. There's a lot of possibilities.
Well, this could be from everything from undue influence, a violation of the Idaho rules of professional conduct, or it could be a due process argument, and that's for the court to make a decision, correct?
Correct.
Okay, Judge, I don't have anything else. I'll defer to counsel.
Very well. Cross-examination, Mr. Evans.
Your Honor, thank you. Professor Newton, can you hear me? I want to ask you, what's the remedy? Do you understand my question? So what would be a remedy to coaching, for example?
So I think it would depend. So I talk about in my declaration one that the Idaho Supreme Court, I recall, countenanced, and I forget where that is in my declaration, which is the trial court brought in the witness. The trial court questioned the witness off the record and said, you know, what did the prosecutor say to you, or you know, whatever happened, you know, in this particular thing, and the court made a determination, the trial court, that the witness was not unduly influenced. So I think one remedy is for the court to question the witness and find out whether she was tainted in some way or not. That's one. Another remedy would be for the prosecutor to voluntarily step down and say, I'm going to avoid this whole appearance of impropriety and let somebody else take that. Another remedy would be the appointment of a special prosecutor. The final, maybe most caustic one would be something like an appellate court coming down and saying that this was improper influence, it affected the due process rights of the defendant, and remanding for a new trial.
The problem that I see, Professor Newton, is when do we know? Because right now we have no idea what she's going to testify to. And so we don't have any idea if it's unduly influenced.
Your Honor, if I may, I'm going to object to the insinuation of what Summer, we don't know what she would testify to. We just had 18 minutes of her statements and listening. So we have an idea based on that statement there. So if we could actually better phrase the question absent the recording, I think it'd be more accurate.
And Judge, quite honestly, the concern is we don't know, that concern isn't what Summer Shiflett is going to testify to. That's a red herring.
Well,
The issue,
Mr. Pryor, there's just a pending question on cross, and there's an objection made by Mr. Means, and I'm ruling the objection. I think I didn't find any grounds to sustain the objection. So,
all right, thank you, Judge.
do you need the question reread, Mr. Newton?
Yes, that would be great.
Right.
All right. If you'll give me just a moment. The question was,
Judge, I can read that back.
okay, thank you.
I believe the last question that I had is, the problem that I see, Professor Newton, is when do we know? Because right now we have no idea what she's going to testify to.
I think how I would answer this, and I mean, I would think it would be in the court's prerogative to determine the best approach, but I don't think it's unreasonable for the court to bring in the witness and ask her, you recall this conversation with the prosecutor, did it influence your testimony in any way? You know, did it cause you to change your opinion about what you wanted to, you know, did you feel pressure to implicate Chad Daybell? Did you feel pressure to get your sister off? If the witness is saying, yes, I did, well, you know, then I think the questions would be, well, then in what ways did you change your statements to the police? And if she did, I mean, those can be corrected in advance of trial, right? If the witness is willing to take the oath and testify truthfully in front of a jury, then I don't see how there would be a problem at trial. But, and of course, that can be fodder for cross-examination. The Supreme Court talks about that in Ash. It would have created a withering cross-examination for defense counsel to talk about how the prosecutor unfairly influenced the witness. And you're opening up that Pandora's box that the court talks about by, you know, having that on there. But I think the court can act in ways to remedy some of those concerns.
Professor Newton, what if she's never called to be a witness?
Well, then I think if you're, so again, this is all just speculating about if her testimony is not important to the case, and then I don't think you rise to the level of a due process violation. But it still could be, because it would have to deprive the defendants of a right to a fair trial. It still can be a violation of the rules of professional conduct. And it still can be, you know, you take a tangential witness and tell them to lie. It's still a violation of the rules of professional conduct and could be criminal as well. Even if she's never called, you just the encouragement is a criminal act. in and of itself.
What do you do with that shit?
Professor Daybell, do you know of any prosecutor that was disqualified by a judge and all the places that you've seen? Have you ever seen a prosecutor disqualified?
Oh, yeah. Yeah.
And for something like this, or questioning a witness?
Your Honor, to the characterization of just questioning the witness, if we actually go back to the recording, Rob Wood asked her one question and the rest was pouring his theory of the case into it. So I object to the question.
All right, why don't you restate the question, Mr. Evans?
Yes. Professor Newton, you've seen what the communication between Mr. Wood and Ms. Shiflett is that correct?
Correct.
Based on that type of communication, have you ever seen a prosecutor disqualified for similar acts?
I've seen a prosecutor disqualified for falsifying evidence, fabricating it in a case. And I have seen prosecutors voluntarily recuse themselves when they've had inappropriate conversations, maybe with a witness. But I've never seen it in my career, never seen a court have to rule on this type of interaction.
And Professor Newton, let me just summarize. So you don't think the conduct crosses a line, even though it might come close to it, it doesn't cross it, is that correct?
Judge, I'm going to object. That's a mischaracterization of what Dr. Newton put in his report. Dr. Newton did not make a determination as to whether this crossed the line or not. What Dr. Newton said is it's up to the court to decide whether this was improper. There are references repeated, and if the court wants me to go through them, I can, of where Dr. Newton talks about this as potentially a criminal act, and he just got finished saying encouragement is a criminal act. Encouragement is a criminal act. So I object. That's a mischaracterization.
Right, and what we're doing right now is called a speaking objection, and I'd really ask you to try to avoid those. We are examining a witness at this point. Everybody's got a chance for argument, but the question that was proposed to Dr. Newton is one that related back to his testimony here. So he can answer that question if he wants, and the objection you've made is overruled. And please refrain from the speaking objections.
Your Honor, may I make an objection? I'll try to avoid speaking. I object to the use of the term cross the line as an oversimplification. There are multiple issues here that have been presented, and those should probably be addressed each one if that's going to be the question.
Well, I understand that, and you can readdress those on redirect or on your direct, but the question is posed. I'll let the witness answer, please.
Thank you, John.
So I think if I recall the question, it could potentially cross multiple lines, but I am not comfortable because I'm not familiar with the evidence in the case, Ms. Shiflett's role, and as well as I don't know if I can fully say what the prosecutor's motives were. But could all of that be across every one of those lines? Yes, but I am not willing to say that because I think it's a legal conclusion that the court.
That's a pot brownie, a pot cookie.
Are you serious?
Just last question. The key with you is the unduly influence. Is that a correct characterization in 2 words? Unduly influence.
Yes,
Is that correct?
I think so.
Well, the key for me is the rule of professional conduct, right? So not knowingly offering evidence that the lawyer knows to be false, not falsifying evidence or assisting a witness to testify falsely, or an inducement, offering an inducement to a witness that's prohibited by law, or engaging in conduct involving dishonesty, fraud, deceit, misrepresentation. So if we're crossing any of those lines in this, those are ethical violations that are big problems.
No further questions, Your Honor.
All right, any redirect, Mr. Pryor?
No.
All right, Mr. Means, do you wish to call the witness?
I do, Your Honor.
All right, Mr. Means represents Ms. Vallow in a separate case. These cases are joined. Dr. Newton, you're still obviously here and under oath, and Mr. Means, you can commence with your direct examination.
Thank you, Your Honor. Dr. Newton, I think it'll be more easier for purposes of my questioning if you have your declaration in front of you so that we could efficiently move through a few questions.
Sure.
Paragraph 20, you make reference to you identified as your first problem. Do you see that line?
Right.
And what exactly is the first problem here that you see in this recorded conversation?
Was, as I identified, that providing a witness with information she does not know and was not available to the public.
And if you could look at the last 2 lines of paragraph 20, why is that the first problem?
So I think that this is kind of fits in the classic wrongful conviction territory. You don't want to be supplanting or giving witnesses memory. And this is well documented in the literature that witnesses are highly suggestible, and especially by someone with authority. And so I don't know what this particular witness's knowledge of the case is, and but the witness is asking questions that she's not familiar with this information. She's being given information about the case, and that can affect her statement to the police if she walks in and says, A, B, C, D, as if she knows those things when she was informed them by an outside witness. So that's just really problematic. It's for a host of reasons.
Thank you. If you look at paragraph 22, your first line of declaration, while Mr. Woods did not follow a best practice, what do you mean by did not follow a best practice?
So this is something, I teach evidence as well, and I talk to my law students about, preparing witnesses for trial and getting ready. And it's so important that you not interject yourself as a lawyer into the evidence of the case. And so you want to get the witness's statement. You want to not influence that in any way, because especially in criminal matters, and especially if you're the state, you don't want to wrongfully convict someone. And that can be even unintentional. You don't realize that you're doing that. So the best practices, and I talk to my students about this, the best practices in witness interviewing are open-ended questions and let the witness tell their story and get that unfiltered narrative first. Now, lawyers often do challenge witnesses, and often, even as a prosecutor, you have to challenge a witness who's being less than forthright. But you want as much as possible to keep this open-ended and non-threatening, because you don't want to influence the testimony. And so that's a best practice, is to avoid doing that.
Thank you. In listening to that recording, reviewing the transcript, did you see one open-ended question in that conversation?
No, and I would give this to my students as a classic example of what not to do. You would never, ever do this, because you are feeding the witness information, and you're just getting yourself in way more problems than you need to get into ever. And you don't want a witness on the stand. This is something I would tell them. You don't want a witness to take the stand and say, well, I didn't really know this, but the prosecutor told me this. And all of a sudden you've become part of this case, and you should never do that. And so if you can collect all of this independently, that's just the best practice. Is it unethical? Does it cross the I don't think it crosses the line of the rules of professional conduct, but I think it's problematic.
You mentioned a phrase, challenge the witness, and you described a little bit about it's okay for attorneys to do that. In challenging a witness, how do you appropriately do that, in your opinion?
Bella's okay.
So what I teach my students, I really like the peace method. And the peace method is you get a person to talk as much as possible, unfiltered, unnarrated. Just tell me what happened. Tell me your story, hours if you have to, and then what happened next. This kind of open-ended, direct examination style of question. Once you get their full statement, do we have everything down? Is that everything you wanted to tell me? Then if you have inconsistencies, if you're a well-prepared lawyer, you have developed a whole host of inconsistencies. You know your case, and you know what they may be lying about. And so then you say, now you told me the red car drove by, but yet, what about this image I have of a blue car? Now you start to confront, and you again leave it open-ended. You show them that there's an inconsistency, and you let the witness try to explain themselves out of that inconsistency. So you do this because the whole goal is to get the witnesses actually, when they are cooperative or they feel it's being cooperative, are more likely to be forthright. with both the police, with the attorney. They even will say damaging things. Oh, maybe I forgot, maybe I'm not remembering this well. And so the less you can make this confrontational, the less likely you're going to influence the witness. And the more likely you're just going to get an unfiltered statement that can be very helpful to you. And when people feel comfortable, they just start sharing, and they often overshare details that can make good lawyering. So that's all. This is the type of best practices I talk with my students about. That would be, when you're interviewing, you need to kind of do this type of thing, because you're going to get a host of evidence that way, as opposed to coming in and just pounding on somebody and getting them to back off.
Would it be accurate to describe this challenging witness as, and what you're describing, kind of boiling it down to asking questions of who, what, when, where, and why type situation?
Exactly.
Right.
That would be, and I mean, it's this interview that I saw here is almost exactly the opposite of what I would tell my students.
That was my next question. Did you see in this interview any who, what, when, where, why question?
Maybe one. Do you know Chad Daybell is my recollection. Maybe one.
The first line of your declaration.
Yeah.
It says the most significant problem for this interview is that Mr. Wood told Mr. Shiflett his theory of the case. And then you reference that she's a soon-to-be witness. That's important, obviously, here. Why is that the most significant problem?
So I think, as I've tried to lay out here, there are some incentives that are put in this situation from just reading the interview itself. I mean, I'm not very fully familiar with the case, other than very, very tangentially the allegations against the defendants, and honestly about it. But when you come in and you tell a witness, here's my theory of the case. Here's how I think this went down. And this witness says repeatedly that she's not necessarily identified with the prosecution. She says, I'm sympathetic to the defendant, I think, and I'm torn between both sides and this type of thing. So she has on the face of this interview, she has some qualms about which side she sympathizes with. But now she knows the prosecution has a theory that Chad Daybell is the more culpable of the two, and she's quite sympathetic to her sister. And then the incentives that I see repeatedly in there are things like, if she cooperates with us, if she wants to talk with us. I mean, the classic, what I said to myself after I heard this interview was, so what he wants is, he wants Ms. Shiflett to talk to Lori Vallow, tell her, hey, go talk to the police, go help him out, throw Chad under the bus, and you might be able to get a sweet deal and save yourself the death penalty. It's exactly the implication I got from it. So the incentive for her is to go talk to her sister and get her sister to cooperate. And she says, I'm struggling with this. Now, how does that affect her testimony down the line? I don't know. And I don't know kind of what happens there, but I find it highly problematic to incentivize a witness to tell a theory, to couch her testimony in a way that would help the state make its case.
You also mentioned the idea of incentivizing or encouraging Summer to speak directly with Lori to cooperate with the state. Is that correct?
That's the implication I got from this interview. The implication felt that way to me.
Are you familiar with Idaho Rule Professional Conduct 4.2?
I am, and it's not coming to me off the top of my head, but I definitely think about it. So
It's entitled Communication with Persons Represented by Counsel.
Correct. Yes, I'm familiar with it.
And I'll read the highlighted portion here. It's a couple sentences. And represented a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyers or is authorized to do so by law or a court order. In your legal opinion, could it be construed that encouraging Summer to speak directly to Lori and to work with the state is potentially violating Rule 4.2?
Yes, and this might be the first time I've thought of this, but I'm thinking of it aloud with you right now, which is if Lori Vallow is a represented person, and this, that was an implication that I got from reading this. The implication was if Lori, it's said directly, I think, if Lori will talk to us, it's going to go better for her. And at least the implied idea is that, you want to get this person cooperating, and that seems like a backdoor way to get around that she's a representative person and you should be working with a lawyer. And matter of fact, even on top of the idea, this is added in there, which is disparaging defense counsel. So it is almost pushing against that, the other ethical rules, which are you're trying to prohibit communication with the other side or inhibit or get around that. I mean, granted, that may require some knowingness that I can't really say, but that's the implication from a outside observer who listens to this. That was the implication I had.
You can stay here. I know, for the night. I don't have.
You made reference.
I know,
to
but I would.
counsel when I was getting there.
I don't feel
there's a
anything,
term or phrase used
so
in
I feel
common
okay. So that's why I just put his car seat base
is
in
that
the
what
car.
phrase you're making reference to?
I feel okay.
You're telling the witness.
As long as I don't stress myself
Vallow's
out, I'll be
attorney
okay.
is incompetent.
Because and now you're not gonna finish doing anything that you're supposed to be doing.
A better attorney is going to come on this case who will encourage her to talk. If she talks, it's going to be
I think he's hungry.
If she communicates,
I have that. I opened this. I saw it. I don't know if it's still good. Yeah.
And so I think
no,
by
there's still.
implication,
I
there is an
opened that.
incentive here to say,
Yeah, it should be in a fridge, but it's not how much it is.
not direct. But the implication is you want to talk to your sister and and I think that is butting against Rule 4.2, which is you should not be communicating with a person except through their counsel. And so, again, I'm thinking about this aloud. I tell my students, my law students, don't do this.
It's in my room.
Don't do this. It's not, no case in your career.
I'm sorry.
If you go
His tummy is
to
hurting. Go get the
paragraph
microphone.
24 and 25. In paragraph 24, you mention and you cite the affidavit of Rob Wood. In the third line on paragraph 24 in parentheses, you see there, we're introductory in nature and not investigative. That's found obviously in Mr. Wood's affidavit he filed with the court. On your next line in 25, the first line, if you would read that, please.
This is not an introductory interview.
Is there any getting to a line, or is it clear in your legal opinion that this recorded conversation was not introductory?
It's introductory to me means, hello, this is my name, what's your name?
Because I can't mute myself because it's coming through.
There has been mentioned before.
I don't know.
Sorry, I just had to shut a door. My kids are home from school, so if there's any interruption.
That's okay. It's been expressed
we're all dealing with this crap because we're all stuck in our homes. We can't do anything the way we're supposed to.
Wasn't part of the recording. That may or may not have included a hello, how are you? I'm Rob Wood.
I think you should eat something right now.
We don't know for sure. We haven't.
What do I eat?
Exactly
I don't know. Is that bread? Yeah.
Even if that is true, following that with the 18-minute recording you listened to, would you still describe the recording as not introductory in nature?
I would not describe it that way.
You're okay. Mommy's getting it. You're okay. I don't know if they can hear me or not because I can't.
At any point in time, let's look at paragraph 26. 5 lines down, where it starts with Wood response.
Oh, I'm live on everything.
Yes.
Say there that Wood responds to the interjection.
I'm live on Facebook, I'm live on
and then
YouTube.
spends the rest of the interview derogating any opinion contrary. Could you explain that, please?
So what I saw, I mean, in this it's almost better classified as a monologue.
It's gonna make. I know. It's gonna be make it. It's gonna make his tummy. Cold makes their tummy more upset.
Thanks to her, as long as she's agreeing, it seems to be okay. But if she makes any statement that is contrary, that gets shut down.
Okay. Okay,
What
you're
kind of
okay.
ramifications does that have for her opinion?
If I mute, they can't hear.
I mean, of course, if the witness. I mean, I don't know. I think only the witness.
I have an idea. Hold on.
Would she have felt pressure?
Listen to it again.
I think so. But again, doesn't affect her identity.
Okay.
I think you testified previously, and correct me if I'm wrong, that you have described this in no lesser terms, at least in coaching. Is that correct? Okay, let's look at bottom of paragraph 26.
Oh, well, that's what I said.
Yes.
You say there the third to the last line starts with however. The interview in reference to this recording borders on
Can you still
influencing
hear
and
them?
potentially unduly influencing Mrs. Shiflett's upcoming statement. That is still your opinion, is that correct?
Correct. However, the interview in reference to this recording borders on
Can you still hear them?
potentially unduly influencing upcoming statement. That is still your opinion, is that correct? Correct. However,
My phone just died.
If you give me a moment, I'm trying to avoid being repetitive here. Let me go through this. If you go to paragraph 33, and you did discuss this case a little bit before. Is it Getters?
Yes.
States? The first two lines, and you quote in the case here, attorney must respect the important ethical distinction between discussing testimony and seeking improperly to influence. I guess I see that, and I see why you cited it, but why is this part of your brief? This specific phrase here from this case.
They're in this way. They're in this aisle vibrating.
The ethical line that the Supreme Court, and I think I talked about this earlier, it's this, Ash and Getters and some of these others. And really, actually, beyond that, I cite in paragraph 33 in Ray Eldridge, which is the common law. The idea is you're supposed to listen to the witness, not pour facts into them, not teach them what they're supposed to know. That's the foreshadowing. That's the prohibited type of coaching, and it's long been prohibited in the common law. Whether it crosses the line of the ethical rules is a little bit of a different question, but it's always been frowned upon as an improper way to do things.
In that same paragraph, later on in number 33 there, you cite the New York Court of Appeals, and you quote, duty is to extract the facts from witnesses, not pour them into him. Would you agree that in this 18-minute conversation that either Mr. Wood, in your opinion, did he attempt to extract any facts, or did he attempt to pour them into the witness?
It was the latter. I didn't see any attempt to find out what this witness knows.
Paragraph 34, you cite Idaho Code 1826043. It's the witness tampering statute. You would agree that the standard for this court to grant suspension of disqualification is not the criminal standard. Is that correct?
Yeah, and I don't know what the appropriate legal standard would be. It's a question of law and fact. So whether that's an abuse of discretion or de novo, I don't fully know. I have not researched that question.
But this court, and this isn't a factual formal question before the court. The court would not have to come to the conclusion that Mr. Wood committed a criminal act in order to be justified in disqualifying him. Is that correct?
The only standard I'm aware of and is the standard for appointing a special prosecutor, which is good cause. There may be other standards that govern that I'm not aware of.
Okay, thank you. Paragraph 35 on page 9. Well, actually, on page 8, the last line, you say one major difficulty of this interview is that Mr. Wood lays out his theory of the case, never attempts to obtain Mrs. Shiflett's version of events, but instead pours his version of the facts into the witness. And then you say, we've already talked about pouring his version of the facts. It sounds an awful like he is teaching her what to say.
Your Honor, I'm going to object. Just on the basis of accumulation on this, we've all got the report. I mean, we've got 10 pages to go of this, so I would subject on accumulation.
I can move forward, Your Honor.
Reserve ruling on that objection. Move forward, Mr. Means.
Yeah, thank you, Your Honor. Paragraph 40 on page 10. You say that a prosecutor should not express his personal opinion as to the truth or falsity of a witness testimony. in your opinion, in listening to this recording and reviewing the transcript, did Mr. Wood express his personal opinion as far as to the truth or falsity of witnesses in this case?
Yeah.
To the defendants in this case?
Yeah.
Thank you. Following that, in the middle of page 40, paragraph 40, it is improper for a prosecutor to express his personal belief or opinion as to the truth or falsity of any testimony or evidence. Did Mr. Wood, in your opinion, express his personal belief or opinion of the testimony or evidence in this case?
Yes.
And then following that, such personal statements constitute misconduct because they are a form of unsworn, unchecked testimony that can exploit the influence of the government. Would you agree in saying yes to those first two questions, that this action has constituted misconduct based on your citing of cases here?
These are cases that apply at trial. So it would be misconduct at trial. Outside of trial, problematic, but I think for all the reasons I've already said, could very well cross those lines, but it would depend on, again, if she was influenced to testify falsely.
Paragraph 41, you say there in the third line, Ms. Shiflett is in a compromised position. Can you explain that?
Yeah, so I think my application here in 41 is the reason that this is a problem in front of the jury is when the government expresses a personal opinion about, the credibility of witnesses in a case, as the court says, that's exploiting the influence of the government and unfairly influencing jurors. Well, that same problem, while the court has not, I don't think, ruled directly on the specific question outside of trial, but that same problem is happening with the witness who is going to feel exploited by the influence of the government, and it is a form of, it would affect, I think, this particular witness and what this particular witness would feel.
Thank you. Paragraph 43, beginning line, the prosecutor increases the pressure on Ms. Shiflett in not so subtle ways. Could you explain what you mean by that?
Let me just look at this paragraph.
What are you doing?
Okay, so this paragraph to me is, and it's something I've referenced before, but by implication of, your sister, there's a strong case against her. I'm not going to pull punches with any particular defendant. And it's in her interest to cooperate. That's the pressure, I think. The pressure is not necessarily on it is on the witness. The pressure is being put to the witness needs to help us help the defendant. Or the defendant is facing some serious charges and some serious, and it's coming after her, and you feel some sympathy toward her. If she wants a break, she's going to have to help us out in different ways. So that's what I think. It's not very subtle to me. It's putting a lot of pressure on the witness to help her sister out.
Can, in your legal opinion, in your expert legal opinion, can pressure eventually become intimidation?
Yeah, absolutely.
Is it beyond reason to think that, or for, again, your opinion, that the pressure, and I believe you use the phrase, increases the pressure and significantly increases the pressure, is it beyond reason that the court could come to a conclusion that Mr. Wood intimidated Mrs. Shiflett?
I think the court could make that finding.
Based on these facts in your recording and the recording that you listened to?
Absolutely.
Paragraph 47. Again, you reference the pressure of the interview in line 1. And then you say it appears she begins to adopt the prosecutor's version of events.
Yeah. So let me look at this really quickly, but
He's having a hard time. I don't know what's wrong.
So there were kind of two things I see going on in this
He
particular
wants
exchange that I
straining.
she starts to kind of make these, well, clearly you know the case for what it is. You've listened to recordings with us. And so this idea that he has special inside knowledge about the case and knows more about it than she does. And so these statements seem to be kind of affirming that like, oh, okay, so you have a lot to teach me. about what I don't know about the case. But then she says, since you've heard the recordings, you know that my sister isn't fully aware of what she's done. I mean, something that would really mitigate the case, right? My sister's not fully, and the prosecutor responds, I think she knows exactly what she's done or whatever. And then the witness says, well, she knew enough to lie to us about it. And so it feels to me like the witness is going out there to say, okay, you know a lot about this, so you're going to sympathize with my sister. And then that's pushed back to say, no, I don't sympathize with your sister. And so it feels to me like the pressure is put on, to kind of shut down those ideas that might be different.
All right, Mr. Means, before you ask another question, I think this would be a good time for us to take a break. We will take about a 10-15-minute kind of mid-afternoon break here, and then you can continue on with your direct examination once we come back on. So,
Your Honor, I just so you know, I don't anticipate going very much longer, but thank you.
Okay, very well. We'll take the break now and then continue.
Oh, he's such a pain in the ass. Oh, God, you just scared him. Okay, guys, so basically we're taking a little break here. I'm trying to get to you guys to do the rest of what we want to do tonight, but this is running a little longer than we had expected. So just keep watching and stay tuned for when this is over. We will be talking about the Nicholas Godejohn Gypsy Blanchard case. I'm going to stop. I'll stop this feed at that time, and then I will start a new one for that so that you guys can watch that. Okay, I'm going to go ahead and just mute for right now so you guys can wait for them to come back. Okay, guys, so this is what I'm going to do. I'm just going to tell you what breaking news we have in the Go to John case. And then I'm going to go ahead and we'll talk about it in greater length tomorrow. Hold on just one second. I know I have to look it up real quick so I can get the terminology correct on what is going on. Okay. Let's see. I'm sorry, guys. Okay. So according to the news leader and now Ozarks First, a couple of people are reporting on this. Nicholas Godejohn is asking the judge to set aside his murder conviction. So according to court records, Godejohn has made the request on Monday, 1/4/21. His attorney sought an extension to file an amended motion. On Wednesday, the judge granted a 30-day extension. He's basically, if I can find it, where is what I'm asking, what I'm looking for? That's not what I'm looking for because I want to tell you exactly what it is. Oh, here we go. Here we go. This is the one. So they tell us exactly. Okay. So basically, there is he's used up his appeals. According to the Missouri Attorney General's Office, post-conviction relief, or PCR. So that's what he's looking for, is a post-conviction relief filing made by Godejohn's attorneys. Is a legal procedure that can take place after the normal appeals process ends. On October 1st, a Missouri appeals court affirmed Godejohn's original court judgment, and February 2019 sentencing records show. So after appeals are exhausted, PCR allows a criminally convicted party like Godejohn to potentially make a few special legal claims: that the trial court had no jurisdiction to convict him, that his sentence exceeds the maximum possible for the crime, or that the conviction or sentence violates constitutional or state law. Most often, the Attorney General's office says PCR is proceeding where a defendant may challenge the actions of his or her own lawyer during the trial and the appeals process. So far, the news leader did reach out to public defender Jenny Young, and she has declined to comment on what Godejohn and his attorneys might argue before the court. So this is a pretty interesting situation that's going on with them. And like I said, we're going to go ahead and postpone updating you more about it and our thoughts, and have Amanda and some of the rest of the team come on tomorrow at some point in time. We will let you guys know. I'm sorry that it took so long today. We were just trying to let the Vallow case play out. I assumed that they would wrap before 5 o'clock in Tennessee. Apparently, no. So we are still kind of following this case with the Vallows. This is a nuts case, man. I'm telling you. So thanks, guys, for watching. Keep on watching. I'm going to go ahead and put it back over to the channel. They should be back in any minute.
All right, everyone, let's go back on the record then. Mr. Means, you were in your direct examination of Dr. Newton. You can continue with your next question.
Thank you, Your Honor. And I'll try to work efficiently here to get through this. Dr. Newton, can you hear me okay?
Yes.
Thank you. Okay, paragraph 50 on page 13.
Okay.
You reference 4 lines down. You say to suggest to a witness that the witness not submit to an interview by opposing counsel. And before that, you reference that it would be improper for a prosecutor or defense counsel to do so. Is that applicable in this situation?
So there are 2 implications, I think, in this ABA standard, which is, the first is that we shouldn't be treating, neither side should treat witnesses as partisans. And witnesses' jobs are to relate the facts and not to take a side or be on one position or another. And so that's an aspirational standard, an ethical standard, I think, that is problematic here. And then it feels to me like the prosecutor in this commentary with Ms. Shiflett is suggesting that she not cooperate with, by implication, with defense counsel. It's not said explicitly, don't talk to defense counsel, but defense counsel doesn't know what he's doing. He's never handled a felony. He doesn't have much experience. All this type of stuff is acting in effect to discourage the witness from cooperating with defense counsel, which is against these standards.
I think you make a reference not to treat witnesses as partisans. Would you, in your expert opinion, say in this interview, this discussion, that Summer was treated as a partisan for the prosecution's case?
I wouldn't say that. I would say no.
Okay. Paragraph 53 on page 14. On the second line after the quotation there, in parentheses, you say, prosecutors have the ability by their choice of language to telegraph to the witness specific facts that the prosecutor wants the witness to say. In your professional opinion, did Mr. Wood telegraph specific facts to Summer Shiflett?
I think the whole interview is Mr. Wood's recitation of facts.
Thank you. Let's go to paragraph 56 on page 15. And actually, let me go down to page paragraph 57. The first line where you cite State versus Sanchez appears to be an Idaho appellate court case, 2005. Prosecutors can commit misconduct when they, particularly with a jury, use a person's religious belief to imply that they are more or less credible. Now, there's been some previous testimony regarding implicating one's religious beliefs or whatnot in a case. And I believe the prior testimony was if you do that in front of a jury, in your opinion, that's potential, that is misconduct, not a lot of question or wiggle room. Would you agree with that?
Correct.
Okay, in this one, it says, particularly with a jury, but would you agree that this line does not limit prosecutorial misconduct when using a person's belief to become more or less credible to just the standard of in front of a jury? If you want to read the line, that might help. The first line there, paragraph 57.
Correct. I've read the line. I'm not sure I understand the question. So.
Okay. So the previous testimony, it's my understanding, correct me if I'm wrong, was discussing the use of religious beliefs in witnesses in front of a jury. And I think, and correct me if I'm wrong, your testimony was there's not a lot of wiggle room not to find that misconduct. Would you agree?
Correct. If you are in front of a jury telling someone because this person is Catholic, they're a liar. That's a classic prohibited.
Sure. This line from Sanchez puts in the middle of the sentence in commas, particularly with a jury, but I read that line as it is not required, according to Sanchez, that a prosecutor find misconduct when he invokes religious beliefs to be more or less credible. Would you agree with that?
I don't want to overstate Sanchez, and I did review it as part of drafting this declaration, but unfortunately I can't remember what Sanchez says. I mean, my recollection is, excuse me, Sanchez is a jury case and a jury misconduct case, so I think it would be tough to take Sanchez out of that context of a jury.
Okay. Would you agree in your expert opinion, or would you state in your expert opinion after listening to the recording and reading the transcript that Mr. Wood, in his comments regarding his religious belief and association, LDS speak, these types of language, that this was an attempt to appear more credible to the witness?
Your Honor, I'm going to object for speculation.
I'll sustain that objection.
Well, I guess, well, let me, in your expert opinion, Dr. Newton, why would the use of a commonality of religious belief be a part of this conversation?
It shouldn't be.
Right.
And it shouldn't be part of the trial proceedings. And does it violate the rules of professional conduct? No, but we're pushing into Rule 610 of the Rules of Evidence, which are that we shouldn't be using religious beliefs for credibility determinations. And so you're potentially influencing the future testimony of a witness and using, this, it just really shouldn't be part of the discussions.
Okay, thank you. If we go to page 16, paragraph 58, you cited Idaho Supreme Court case. And in there, it appears that court case talks about the responsibility of the prosecuting attorney. Correct. It calls them acting in a quasi-judicial capacity.
Correct.
Would you agree in your review of the Idaho Rules of Professional Responsibility that the prosecutor is subject to all of the rules, just like a civil attorney, to the Idaho Rules of Professional Responsibility? Is that a yes?
Yes.
And there's specific rules in addition to, in the Idaho Rules of Professional Responsibilities, that a prosecutor has to comply with, correct?
Correct. And I think I even laid that out toward the front of my declaration of the Idaho Rules. I mean, specifically, it's layout 3.8. There's my memory, but 3.8 is a provision that applies specifically to prosecutors. They have additional ethical guidelines. And I point that out to my students pretty frequently, which is the drafters of the rules of professional conduct have felt very strongly recognizing this common law principle that the Idaho Supreme Court recognized 120 years ago, which was that prosecutors carry a mantle greater. It's attorney plus. Not only are you just an attorney and you're bound by these ethical rules, you have greater rules that you are supposed to not be the one that's like choosing a side. You're supposed to be independent, looking at the evidence and actually making decisions to dismiss cases. That's where a prosecutor's greatest power is, in not over influencing witnesses, making sure justice is done in a case and not becoming a partisan. And it's a very, very important responsibility that is grounded in the common law, but also in the rules of professional responsibility.
Thank you. Page 17, paragraph 60. You state, while the prosecutor here did not expressly threaten to charge Mrs. Shiflett or even told her she was not a person of interest, he put pressure on her in other ways to give testimony that would implicate Daybell. And then it goes into particular. When you say Daybell there, I assume you're in reference to Chad Daybell. Is that correct? So again, we have another instance of pressure that we discussed earlier.
Correct.
Okay. Paragraph 62.
Yes.
You make reference in the second line to pretrial taint hearings.
Correct.
How could you explain how that applies here?
Yeah, so I mentioned this earlier. I testified about this, but this is definitely something among scholars, law professors like me, who talk about this is a way to address some of these problems, which is to have a pretrial taint hearing. That's where the court evaluates the credibility of the witness, and if the witness has been tainted, if her testimony has been improperly influenced. And it has some backing in courts. And I searched in Idaho, and there's at least the Supreme Court at least countenanced that type of a remedy. And I'm looking at the affidavit now, but it says that it's the Severson case, where the witness went to lunch with the prosecutor, and there was allegations of impropriety that the prosecutor improperly coached the witness, and the court countenanced the trial court's use of a pretrial taint hearing. Well, actually mid-trial in this case, but a taint hearing to kind of assess whether the witness's testimony had been affected.
Okay, thank you. If you'll turn to page 18, paragraph 65, you cite the ABA standards.
Yeah.
You state that the prosecutor should not discourage or obstruct communication between witnesses and the defense counsel. Is it your expert opinion that Mr. Wood has potentially obstructed communication between the witness and defense counsel?
At a minimum, it feels like there's discouraging communication. And again, it's not expressed, don't talk to defense counsel, but defense counsel is not credible and not acting in your sister's best interests. That's would, in effect, I think, discourage most people, or in its attempt to discourage people.
Would you agree that it obstructs communication?
It could. It could. It would depend on if the witness the witness would have to feel like they couldn't. And there's a whole litany of cases. I mean, I talk about these in my classes. There's a litany of cases where prosecutors have obstructed witnesses' access to defense attorneys and say, if you talk to this person, I'll do that. And that's where that really crosses that line of, you talk to this person, I'm going to come after you. And that really is problematic. This is much more muted than that.
Line 66 starts off there with during trial. You see that?
Yes.
It is misconduct for the prosecution to make personal attacks on defense counsel. Putting aside the during trial, is there any question in your mind that the prosecution, through his negative comments regarding counsel, engaged in a personal attack on defense counsel in front of this witness?
Yeah, it's misconduct in trial.
But my question is, take it outside of trial, put the trial setting aside, his comments regarding counsel to defend this witness, would you classify that as, in your expert opinion, as a personal attack on defense counsel?
Yes, I would call it a personal attack on defense counsel. Sure.
Your Honor, I have no further questions. Thank you.
All right, Mr. Evans, cross-examination.
Your Honor, thank you. I'll be short. Professor Newton, just to make sure, and I've looked at what you've said in your briefing, but there is a very big difference between what occurs at trial and what occurs pre-trial. Is that correct?
Yes.
And I don't see anything in your document that isn't something that occurs prior to trial. All of it is what occurs in trial. Am I reading that correctly?
I wouldn't say so, no. Clear, you have the appellate court stepping in and saying clear misconduct and certain things happen at trial, but that doesn't mean all these rules of professional responsibility and all these other things can't be violated pre-trial. or that the Constitution can't be implicated pre-trial.
But the cases that you cite, all of them that I looked at are all during trial.
Correct. I'm not aware of, at least in my research, I didn't see an Idaho case. Now, I limited my search to Idaho, but of courts addressing this pre-trial. But I know that this problem happens pre-trial. It's not just limited to that scenario.
Right. And Professor Newton, we don't have any evidence that Ms. Shiflett changed her story at this point. Is that correct?
I can't even go that far. I don't know if Ms. Shiflett testified about anything.
And would you agree with me that at no time did Mr. Wood say, Ms. Shiflett, you will testify to X, Y, and Z, whatever that is?
No, he told her to tell the truth, but I would say that there is definitely a pushback on that. But he did not expressly tell her to lie, if that's the question.
No further questions, Ron.
All right, thank you. Mr. Pryor, do you have any cross-examination in light of?
Judge, I'm going to be extremely brief as well. Dr. Newton, would you think that it's commonplace for a recording to surface about a prosecutor having a discussion with a witness? Is this a scenario that would come up regularly?
No, I hate to maybe put it this way, but it's like you got caught.
Okay, and that's why we're here today, because Mr. Wood got caught, right?
What it feels like. It's very uncommon.
Objection.
What's the
Yes.
objection, Judge?
Speculation and testifying that Mr. Wood got caught.
Great.
I'll overrule on those grounds.
So Mr. Wood got caught, and this sort of scenario is not commonplace, is it?
No. I mean,
The reason we have Supreme Court cases about prosecutorial misconduct in front of juries is because that appears and happens when everybody's watching, right?
correct.
And when no one's watching and a prosecutor engages in this, the only way to catch him is through finding a recording that he did this. Would you agree with that?
So I think maybe the best way for me to qualify this is say, you know, I've practiced law for a long time. I've represented thousands of defendants. I've worked on both sides of the aisle. Rarely in my experience does a prosecutor record an interview with a witness and so number one, there just aren't recordings, generally speaking. That's not provided to defense counsel as part of discovery. Contrary to that, detectives frequently record their, and police officers do. And so in answer, I think, to the question is, if this stuff is happening, it's because it's not being recorded and we're not able to see it happening because it's just not there. But it's the rare case that a recording surfaces, and then we can talk about the problems that are happening that we observe.
Nothing else, Judge. Thank you.
All right, thank you. Mr. Means, any redirect?
Taking the totality of the circumstances, Dr. Newton, in your professional expert opinion, is it more problematic for this case moving forward to allow Mr. Wood to continue to represent the state or for him to be disqualified?
Your Honor, I'll object to that. Calls for a legal conclusion and a speculation for the court to decide, not Professor Newton.
I'll sustain the objection that it does call for legal conclusion.
Thank you, Your Honor. No question.
All right, thank you. Dr. Newton, before we finish your testimony, I did have a question. You testified that you were aware of cases where a prosecutor had been disqualified, and I'd like a little more clarification of that. Are you aware of any cases where a sitting trial judge in a pending case pre-trial has removed a prosecutor?
I am sorry. Where's my dogs? Hold on.
So I'm not the only one that has dogs. That's good.
We have the mailman show up, so the dog has to make sure they don't like him. Am I aware of cases where what?
Where a sitting trial judge in a case pre-trial has ordered a prosecutor to be removed from the case?
No, Your Honor. I am not aware of any that that's happened.
Okay, thank you. That was the only question I had. Thank you, Dr. Newton. That'll conclude your testimony then. So you can be excused and go ahead and log off of the hearing. Thank you. All right, Mr. Pryor, do you have any additional witnesses to call?
No, Judge, that's all for the defense. Thank you.
All right, Mr. Means, do you have any witnesses you'll be calling in support of your motion?
No, Your Honor.
All right, and will the state be calling any witnesses in opposition?
No, Your Honor.
All right. Counsel, here's kind of where we are. We've taken a lot of testimony today. It's 4:30. I was kind of sitting where I'd like to get this issue resolved quickly, but I would also like to allow time for the parties to prepare their final closing arguments on these motions, given the volume of testimony we received. So I'm going to make a suggestion. Feel free to weigh in, but I'd like to continue the hearing for final argument, assuming there's no more testimony being submitted. And I have some availability tomorrow morning and all day Friday as an option if we can squeeze that in this week. I know there's a lot of calendaring to consider here, but is counsel going to be available at any of those times to do that?
Your Honor, let me go grab my calendar real quick.
All right.
Your Honor, just for the record, I'm available Friday, but not Thursday.
Okay. Thank you.
And I can do in the morning if that works, or the afternoon, whatever works for the court.
Judge, I can bounce some obligations around Friday morning if necessary to allow for closing argument. I have no idea how long that's going to take, but I would imagine based on what we've gone through that it's going to take a little bit of time.
Okay. So Mr. Evans, where we're kind of at is both counsel are available Friday morning and the court is as well. I also need to check with Fremont County. Madam Clerk, is there any issue with us Friday morning having another?
No problem. No problem here, Judge.
Okay, thank you.
Your Honor, I have a contempt matter, a compel matter, and then also a mediation that morning, but I can work something in Friday afternoon.
Okay. That works for me as well. Is that available on your schedules, Mr. Pryor, Mr. Means?
Yes, Your Honor.
Yes, Your Honor.
Okay, could we start that right at 1 o'clock, Mr. Evans?
Did you hear? Yes, I am. Your Honor, yes, that should be okay.
Okay. Appreciate your accommodations on that. So unless there's nothing further to bring up this afternoon, then we'll be in recess. We'll continue the matter for the closing arguments of the all parties.
Your Honor, can I bring up one thing?
Yes.
Would the court be willing to consider a briefing on this? And the reason why I say that is we just received these documents that were talked about today, just a couple of days ago. I think that it would benefit the court. We see the end where the defense wants to go. They want to get rid of Mr. Wood as the prosecutor, but I don't see the path that's been laid on how to do that. And so some standards for the court to look at. We'd be prepared to offer the court briefing. In fact, even summarize our argument in the briefing if the court wants. But the state would require, unless the court is happy to do all that research itself, but we're here to assist.
Judge, I'm opposed to doing a briefing. All I see is a delay. I'm concerned that they have an opportunity to review these things and can make their argument and present the case law that they think is applicable. As far as Mr. Evans' representation that he doesn't see a path to this, I strongly disagree. I see a highway to this. And quite honestly, I think oral argument would be the preference for me. In the event the court decides to disqualify Mr. Woods, we can move on with some serious pending matters before the court. If the court decides to go otherwise, we still have some serious pending matters to address. And my view is that a briefing is merely just a delay. Mr. Daybell has had to incur the cost of this by no fault of his own. a significant cost, and briefing is only going to elevate that cost.
All right, Mr. Haynes, anything you'd like to add on the suggestion?
Yeah, briefly. Thank you, Your Honor. I have to agree with Mr. Pryor and reiterate what he said. I think the opportunity for briefing was when this motion was noticed. Everybody knew what the issue was. Everybody knew what the accusation was. Everybody had a copy of the recording. There were no surprises there. There are plenty of opportunities to do legal briefing or analysis or presentation to the court today, why in previous memorandums or additional declarations, and they chose not to do that. If the court entertains that idea, it's a substantial cost to my client. I think it's unnecessary. It's going to prolong this issue. I would definitely obviously request for an opportunity to time to respond to their briefing, because there was no argument presented other than cross-examination today. I have no idea what they're going to argue. There's no additional testimony other than what's been presented to the court. We would need adequate time to respond. And now we're talking about several weeks in order to resolve this, when we've already pushed off multiple motions in order to accommodate this hearing. So I'd agree with Mr. Pryor that the briefing is not allowed. Closing arguments on Friday tomorrow should be sufficient. There's nothing that stops opposing counsel from arguing tomorrow on what the standard should be in his closing argument and the things that he cited. And again, this motion has been noticed for quite some time now, and there's no surprises here.
All right. Well, I've considered the request, and really for the reason that I think this is an issue that does need to get resolved in an expeditious manner. I do want to get the answer to this done sooner than later. Briefing is going to extend that, and as the parties have mentioned, we've got other motions we bumped off, including the motion to change venue and the motions to dismiss, which still need to be scheduled. In light of all that, I'll deny the request for the briefing to, I won't deny the request for briefing if you want to have any briefings submitted, and I know this puts you on a very tight timeline, but it would need to be submitted by Friday at 1 o'clock on the 8th, when we have the continuation of this hearing. So you're free to submit anything. It doesn't even need to be all that formal. If you have some certain cases you'd like to cite or lay out, I've done some research already. I don't know that there's really a whole lot of precedent out there to get into on this specific issue, but I'll leave that for the parties to argue as well. Any citations you want to include in your argument or submit those prior, you can just do that on this shortened time frame. I'll just consider oral closing arguments and any briefing you want to submit between now and Friday, and then we'll get this matter concluded by the end of this week. So that'll be the ruling for today on that motion, and then we will continue on with the hearing at 1 o'clock on the 8th of January. That will also be by Zoom. We'll send the notices out. Counsel, I appreciate the way you've conducted yourselves today in the hearing. And if there's nothing further for this afternoon, then we'll be in recess.
Thank you.